Good afternoon, Chair Brzezinski, Vice Chair Thatcher, members of the committee. For the record, my name is Annessa Hartman. I am the state representative for House District 40, which is Gladstone, Oregon City, and parts of unincorporated Clackamas County. Thank you for this opportunity to bring you House Bill 2975A, a survivor bill that corrects a harmful legal technicality and restores our basic sense of fairness in our justice system for survivors of domestic violence. Right now, Oregon law treats strangulation and fourth-degree assault as distinct crimes, except when they happen in the context of domestic violence. Why? In the 2024 State v. Miles case, the Court of Appeals ruled that when a jury finds that when an offense constituted domestic violence, it essentially requires a merging of charges for multiple offenses into a single offense. This means that in a case where an abuser strangled, menaced, and assaulted a victim, they could only be convicted of one charge instead of the 3 separate acts of harm they truly caused to their victim. What is even more concerning is that the State v. Miles case only conferred this interpretation to crimes of domestic violence, meaning if those same 3 offenses were committed in a non-domestic setting, the defendant would be convicted of all 3 offenses. As we know, strangulation is not just another form of assault. It is one of the most violent and life-threatening forms of domestic violence an abuser can commit. Studies show that victims who have been strangled by their abuser are 750% more likely to be killed by that abuser in a future attack. The act of strangulation can lead to long-term brain damage, change in vision, long-term memory issues, and delayed fatal consequences. And when someone strangles their partner, they are demonstrating control over whether that person lives or dies. And when a survivor lives through that, they carry not just the physical trauma, but the terrifying knowledge that next time they might not make it out. And I want to share an example of a recent case from Clackamas County where this opinion has already negatively impacted a domestic violence survivor. The defendant strangled and punched his girlfriend repeatedly, a victim he had unfortunately assaulted previously, and he pleaded guilty mid-trial to strangulation and assault 4, but because of the State v. Miles case, the convictions for strangulation and assault merged, and he only had 1 conviction. And to me, that is not how our justice system should treat survivors, and it is not justice. The modifier constituting domestic violence was meant to protect victims. It has helped ensure restraining orders are granted, firearms are prohibited, and child custody decisions take abuse into account. But because of how our law is currently written, applying that label weakens accountability by collapsing multiple charges into one. House Bill 2975A fixes this. It clarifies that a pleading, admission, or finding that a crime that involved domestic violence is not an element of a crime, but rather a classification that provides important protection for victims. It allows our courts to treat individual acts of harm like strangulation or assault as separate harms they are, even if they occur in a relationship. Chair, members of the committee, I know we don't get a ton of FaceTime with each other, but as some on this side may know, I am very open and transparent about being a survivor of sexual assault and domestic violence, which can sometimes make bills like this really difficult and triggering for me to work on, especially when I have to work with those lawyers. No offense to the lawyers, but sometimes you make it difficult for me. But I really made a commitment to center the voices of survivors in this building, and House Bill 2975 does that. It is a bill that is a reflection of months of work done by district attorneys, defense attorneys, the courts, DOJ, but most importantly, the survivors who were impacted were at the center of this policy. And I'm really, really proud of this bill and that it passed unanimously and all of the work that went into this. And I want to thank you for the opportunity to bring this forth to you, and I urge your support of House Bill 2975A.